Have you ever pondered over the intricacies of divorce within the Islamic tradition? It's a topic that's often misunderstood. So today, we're going to delve deep into this subject, shedding light on the divorce procedure as outlined in the Quran, Hadith, and major Islamic jurisprudence schools, also known as Madhabs. Firstly, it's crucial to understand that divorce in Islam isn't as straightforward as simply signing a piece of paper. It's a comprehensive process that requires careful consideration and is guided by profound principles. In the Quran, the Holy Book of Islam, divorce is described as a last resort, taken only when all efforts towards reconciliation have proven unsuccessful. It's not a decision to be taken lightly, but rather a measured response to an irreparable situation. The first step in this process is known as iddah, a waiting period that serves as a time for reflection, reconciliation, and confirmation of potential pregnancy. This period lasts for 3 menstrual cycles, or 3 lunar months for women who no longer menstruate. During this time, the husband is responsible for the wife's maintenance, and they continue to live under the same roof, but without engaging in marital relations. If reconciliation occurs during iddah, the divorce process can be halted. However, if the issues remain unresolved, the divorce process moves to the next stage. The second step involves the declaration of divorce. According to the Quran, the husband is to pronounce talaq, meaning divorce, in the presence of 2 witnesses. This declaration can be revoked within the iddah period, allowing for the marriage to continue without the need for a new marriage contract. This is known as talaq raji, or revocable divorce. However, if the husband pronounces talaq 3 times, either at once or on separate occasions, this leads to talaq ba'in, or irrevocable divorce. In this case, the couple cannot remarry unless the wife marries another man, the marriage is consummated, and then she gets divorced or widowed. On the other hand, a wife can seek divorce through a process known as khul, where she offers a compensation, usually returning her dowry to the husband in exchange for a divorce. This requires the husband's agreement, and if he refuses, she can take her case to an Islamic court. In the second scene, we'll delve into the significant role that mediation and counseling play in the Islamic divorce process. In many Muslim jurisdictions, before divorce proceedings can formally begin, attempts must be made at reconciliation. This is especially common in Sunni Islam, where it's seen as a necessary step to ensure that all options for mending the relationship have been thoroughly explored. Mediation could involve a neutral third party, often a respected figure within the community, who facilitates discussions between the couple. This person could be a religious leader, a family elder, or a professional counselor. Their role is to help the couple navigate their differences and explore possible solutions to their conflicts. Counseling, on the other hand, can be offered by a trained professional who can provide the couple with the necessary tools to communicate effectively, manage their disagreements, and make informed decisions about their future. It's important to note that these reconciliation efforts are not meant to force the couple to stay together against their will, but rather to ensure that the decision to divorce is made with clarity and understanding. If these attempts at reconciliation prove unsuccessful, then the formal divorce process can proceed. This underscores the emphasis within Islamic law on maintaining the sanctity of marriage and the importance of making every effort to preserve it before opting for divorce. This scene sets the stage for the next, where we will walk you through the step-by-step procedure of divorce under Muslim family law. In this scene, we will compare the divorce procedures in Islamic law and civil law. Both systems have distinct steps that a couple must follow when seeking a divorce. In Islamic law, reconciliation attempts through mediation and counseling are mandatory before the official divorce proceedings can begin. This step is taken to ensure that all possible solutions to mend the relationship have been explored. On the other hand, civil law does not necessarily require reconciliation efforts before filing for divorce. Although mediation is often encouraged, it is not a prerequisite. In Islamic law, the husband can initiate divorce by pronouncing talaq 3 times, or the wife can seek divorce through khula with the husband's consent. In contrast, civil law requires one or both spouses to file a petition for divorce, outlining the reasons for the dissolution of the marriage. Islamic law includes the iddah period, a waiting time for reflection and potential reconciliation before the divorce becomes final. This period also serves to confirm a possible pregnancy. In civil law, there is no such waiting period, and the divorce is finalized once the court issues the decree. One of the main differences between the two systems lies in the grounds for divorce. While Islamic law focuses on the broad concept of marital discord, civil law requires specific grounds like irreconcilable differences, adultery, cruelty, or abandonment. Lastly, while both systems involve negotiations over child custody, spousal support, and property division, the specifics can vary greatly based on cultural, societal, and legal contexts. Join us in the next scene, where we will delve into the detailed procedure of divorce under Muslim family law. In this section, we'll be walking you through the step-by-step procedure of divorce under Muslim family law. The initiation of divorce can be done by the husband or the wife. In the case of the husband, he can initiate a divorce, also known as talaq, by pronouncing the word talaq 3 times. However, this method is often discouraged due to its contentious nature. As an alternative, the wife can seek divorce through a process called khula. This involves the husband's consent and often includes the return of the dowry she initially received. Before formal divorce proceedings are initiated, some Muslim jurisdictions necessitate attempts at reconciliation. This could involve counseling or mediation and is particularly common in Sunni Islam. If these attempts prove unsuccessful, then the process moves on to the documentation stage. The documentation is often prepared by a religious authority or a legal professional. It outlines the terms of the divorce, including any financial settlements and custody arrangements for children. Once both parties agree to these terms, the divorce is pronounced, and the iddah period begins. The iddah period is a waiting period during which the couple remains legally married. This period lasts for 3 menstrual cycles or 3 lunar months if the woman is not menstruating. It serves as a time for reflection, potential reconciliation, and confirmation of pregnancy, if applicable. Finally, after the iddah period, the divorce becomes final. Both parties are then free to remarry. This comprehensive process ensures fairness and respect are maintained throughout, providing both parties with ample time and opportunities for reflection and reconciliation. In this third scene, we will draw parallels between the divorce procedures under Islamic law and civil law. While both systems aim to ensure fairness and respect, the methods and steps involved differ significantly. In civil family law, divorce proceedings are usually handled by family courts or relevant civil courts, depending on the jurisdiction. The grounds for divorce in civil law systems can range from irreconcilable differences to adultery, cruelty, or abandonment. Unlike the Islamic law, where the husband or wife can initiate the divorce, in civil law, one or both spouses file a petition for divorce with the appropriate court. This petition outlines the reasons for the divorce and any requests for child custody, support, alimony, and division of assets. If the spouses can negotiate or mediate to reach an agreement on these issues, the settlement is presented to the court for approval. If no agreement is reached, the case proceeds to court, where each party presents their arguments and evidence. The court then makes decisions on contested issues based on applicable laws and previous court decisions. Once all issues are resolved, the court issues a final divorce decree, officially dissolving the marriage. And unlike the Islamic law, in some cases, either party may appeal the court's decision if they believe there were errors in the legal process or if they disagree with the outcome. By comparing these two systems, it becomes clear that while the procedures may differ, both aim to ensure the rights and interests of all parties involved are protected. This brings us to the Hadith, the sayings and actions of the Prophet Muhammad. The Hadith provide further guidance on divorce, emphasizing the importance of treating each other with kindness and fairness. The Prophet Muhammad is reported to have said, "Of all the lawful acts, the most detestable to Allah is divorce." Finally, we turn to the Madhabs, the major schools of Islamic jurisprudence. The four main Sunni Madhabs, namely the Hanafi, Maliki, Shafi'i, and Hanbali, all agree on the basic principles of divorce, but they differ on some details. For instance, the Hanafi school allows for a triple talaq to be pronounced in one sitting, while the other three schools consider this practice as highly discouraged. To summarize, divorce in Islam is a multi-stage process that emphasizes patience, reflection, and fairness. It begins with a waiting period called iddah, followed by the declaration of divorce or talaq, which can be revocable or irrevocable. A woman can also seek a divorce through khul. The Hadith and the Madhabs offer additional insights, underscoring the gravity of this decision and the importance of mutual respect and kindness. Remember, the aim of this discussion isn't to encourage divorce, but to understand it from an Islamic perspective. It's a topic that deserves our attention and understanding, and we hope this discussion has helped provide that. Until next time, continue to seek knowledge and strive for understanding. Now, let's shift our attention to another crucial aspect, that is, how to get a divorce in a civil court in the UK. Just like any other legal process, divorce has its own set of requirements and procedures in the UK. Firstly, you must meet certain legal requirements. For instance, you must have been married for at least a year, your relationship has permanently broken down, and your marriage is legally recognized in the UK. Secondly, the divorce process itself involves multiple steps. It begins with filing for divorce, which requires you to fill out a divorce petition. Next, serving divorce papers to your spouse, which means formally notifying them of the divorce proceedings. And finally, attending court hearings, where the court will review your case and, if all requirements are met, grant the divorce. Now, you might be wondering how Islamic divorce procedures can be incorporated into this process, right? Well, it's important to understand that UK civil law and Islamic law are separate legal systems. However, you can still uphold your religious principles during the process. For instance, you can perform the talaq or khula during the waiting period of the civil divorce process, ensuring that both religious and legal procedures are respected. Remember, it's crucial to consult with a legal professional when navigating the divorce process in a civil court. They can provide guidance tailored to your unique situation and ensure that your rights are protected throughout the process. This way, you can navigate this challenging time with confidence and peace of mind. In the next part, we will be exploring more about the societal impacts of divorce. Now that we've discussed the Islamic and UK civil court procedures for divorce, let's take a look at how divorce is handled in civil law around the world. Divorce laws and procedures can vary significantly from country to country, reflecting the diverse cultural, religious, and legal traditions across the globe. But despite these differences, there are some common steps in the divorce process in civil law. First, the divorce process usually begins with one spouse filing for divorce in court. This involves preparing and submitting a divorce petition or complaint, which outlines the grounds for divorce and how the filing spouse wants to handle issues like property division, child custody, and alimony. Next, the other spouse is served with the divorce papers, which means they are formally notified of the divorce proceedings. They can then respond to the divorce petition, either agreeing with or disputing the proposed terms. Finally, the spouses attend court hearings, where the judge reviews the case and, if all requirements are met, grants the divorce. The court also makes decisions about property division, child custody, and alimony, unless the spouses have already agreed on these issues. Now, let's briefly discuss how different countries handle these issues. In some countries, property acquired during the marriage is divided equally between the spouses, while in others, the division is based on factors like each spouse's contribution to the marriage and their financial needs after divorce. Child custody can be granted to one parent or shared between both, depending on what the court determines is in the best interest of the child. As for alimony, it is usually awarded based on the recipient's need and the payer's ability to pay, but the specifics can vary widely. Remember, it's always important to consult with a legal professional when navigating the divorce process in any country. They can provide guidance tailored to your unique situation and ensure that your rights are protected throughout the process. This way, you can navigate this challenging time with confidence and peace of mind. In our next segment, we will delve deeper into the societal impacts of divorce. But for now, let's pause and reflect upon the information shared. In the complex world of divorce proceedings, legal aid can be a lifeline. It's a provision of assistance, often financially, to those who are unable to afford legal representation and access to the court system. This aid is designed to ensure that everyone, regardless of their economic status, has the chance to exercise their rights under the law. Let's discuss the latest family law on this matter. In many countries across the globe, legal aid is available for divorce or defense in divorce proceedings. The eligibility criteria can vary, but typically it's aimed at those who have a low income, have few or no savings, and cannot afford a lawyer. Some countries also consider factors like the complexity of the case, the potential outcomes, and whether the applicant is a victim of domestic violence. The aid can cover a range of costs, including legal consultation, preparation of court documents, representation in court, and even some out-of-court negotiations. Remember, though, legal aid is not a free service. It's a loan that usually has to be paid back, often from the settlement received in the divorce. Applying for legal aid often involves providing detailed information about your financial situation as well as the specifics of your case. This might include proof of income and assets, details about the marriage and reasons for divorce, and any evidence of domestic violence or abuse. Some countries have legal aid clinics or online platforms where you can apply for aid, while in others, you might need to apply through a lawyer or legal representative. Remember, legal aid is there to help those who need it most during divorce proceedings. Always consult with a legal professional to understand your rights and options. They can guide you through the application process, help you prepare your case, and represent you in court, ensuring that you receive the support you need during this difficult time. In the next segment, we will delve deeper into the societal impacts of divorce. But for now, let's absorb this valuable information. Do not forget, if you like this video, click on like, subscribe, and share. In this section, we will discuss the divorce procedure from both Muslim and civil family law perspectives. It's essential to understand that these two legal systems can have significant differences in their approach to divorce, primarily due to their unique cultural and religious contexts. Firstly, let's look at divorce procedures in Muslim law. In Islam, divorce is seen as a last resort and is highly discouraged. However, it is allowed in certain circumstances. The process typically begins with a period of arbitration where the couple attempts to reconcile their differences with the help of mediators. If reconciliation fails, the husband can pronounce a talaq, effectively ending the marriage. Alternatively, the wife can request a khula, which is a divorce initiated by the wife, but it requires the husband's consent. On the other hand, civil family law in many countries requires a legal process to be followed. This usually begins with one party filing for divorce and providing a valid reason, such as irreconcilable differences, abandonment, or cruelty. The other party is then served with the divorce papers and has a chance to respond. If both parties agree to the divorce and its terms, the process can be relatively straightforward. However, if there are disagreements, particularly over property division, child custody, or spousal support, the process can become drawn out and complicated. Islamic courts and civil courts play different roles in these divorce proceedings. Islamic courts primarily focus on ensuring that Islamic laws and principles are adhered to during the divorce process. They also aim to make sure that the rights of both parties, particularly women and children, are protected. Civil courts, meanwhile, aim to resolve disputes fairly and evenly based on the laws of the land. They focus on ensuring that both parties have an equal say in the proceedings and that any children involved are adequately protected. Cultural and religious beliefs can significantly impact divorce procedures. In some cultures, divorce is stigmatized, and individuals may face social ostracism. In contrast, other cultures may view divorce more neutrally. Religious beliefs can also play a crucial role. For instance, some religions may discourage or even prohibit divorce, while others may allow it under specific circumstances. Understanding the divorce procedure from both perspectives can help individuals navigate this challenging process more effectively. It can also help to ensure that their rights are protected and they can make informed decisions about their future. Remember, it's always advisable to seek professional legal advice when dealing with divorce proceedings. In the next segment, we will discuss the societal impacts of divorce. Stay tuned and remember to like, share, and subscribe if you find this content helpful.